All right, buckle up because this courtroom exchange is about to go completely off the rails. What you're about to witness isn't just a legal hearing, it's a collision between established law and a man determined to operate in his own version of reality. We've got Robert Geese stepping into court, not just to defend himself, but to challenge the very foundation of how courts function. Now, here's where things get interesting. Instead of a typical defense strategy, lawyer, evidence, arguments, we're about to see a flood of legal-sounding phrases, special appearances, and identity claims that don't quite hold up in an actual courtroom. And if you've seen cases like this before, you already know, this rarely ends well. The judge, calm but firm, is going to try multiple times to bring things back to reality, explaining rights, procedure, and the seriousness of waiving legal counsel. But the real tension? It comes from a fundamental disconnect. One side is playing by the rules of law. The other is trying to rewrite them mid-game. And trust me, you'll want to pay attention to how this unfolds, because by the end of this hearing, one critical decision will shape everything that follows. Will the defendant accept how the system works, or continue doubling down on a strategy that could completely unravel his case? Let me ask you this right now. If you were facing criminal charges, would you trust your own interpretation of the law, or rely on someone trained to navigate it? Let's get into it.
A corporation or a statutory person. I'm a natural, freeborn national of the territory of Colorado, known as a Coloradan. If I may, I would like the court to take judicial notice that the written record thus far is incorrect. As said, I am here propria persona. I am not here pro se, nor am I here pro per. It's important that that be documented and on the record. I have submitted a motion of discovery and an affidavit of truth. Has the court received and reviewed those documents?
If you want to request discovery, you need to do that through the district attorney's office.
I've done that.
Okay.
And the documents are recorded. Sir, did you?
I have received your request for discovery. It is being processed at this time, sir.
Okay. With that in mind, I don't know how this court can proceed without the affidavit being rebutted, answered, and discovery being taken care of.
That's not how this works. So the court is not the one that goes through the discovery. If you want to talk to the DA regarding plea offers in the case, I'm happy to set over for you to do that. If you're going to hire a private attorney, or if you want a referral to the public defender, I'm happy to set another day for you to get that done as well.
Would you like to discuss the matter now, sir?
This right here is a classic misunderstanding of how the legal system operates. The defendant believes that simply filing an affidavit or requesting discovery somehow pauses or blocks the court from moving forward. But that's not how criminal procedure works. Discovery is handled between the defense and the prosecution, not dictated by the court in real time during a hearing like this. What's happening is the judge is trying to redirect him toward actual legal options, get a lawyer, review evidence properly, or negotiate with the prosecution. But instead, he's doubling down on technical language without applying it correctly. And here's the real issue. Confidence without legal accuracy can be dangerous in court, because while he believes he's asserting control, he's actually giving up strategic ground. So let me ask you, do you think the court should slow things down for someone who doesn't understand the process? Or is it their responsibility to come prepared?
I understand that. I respect that. I will object to it, and I don't consent to it. But let's proceed.
All right. So I need to go through an advisement with you regarding your right to counsel. Do you understand that you have the right to be represented by counsel in your case?
Yes.
Do you understand that if you cannot afford an attorney, one would be provided to you free of charge if you qualify financially for the public defender?
I am here propria persona.
Do you understand that the charges against you in this case are driving under a revoked license and careless driving? They're both class 2, the careless driving is a class 2 misdemeanor traffic offense that carries up to 10 days to 90 days in the county jail. The driving under revoked license is as a Class A traffic infraction and carries a possible fine. Are you under the influence of any medication, drugs, or alcohol that would affect your ability to think clearly?
No.
Do you wish to consult with the public defender before you make a decision to waive your right to an attorney and represent yourself?
No, I do not, and I do not waive my right to trial by jury.
Have you ever studied law?
I don't know how that is relevant to the case, Your Honor.
I'm trying to make sure that you're knowingly, voluntarily, and intelligently waiving your right to counsel.
I am.
Have you ever represented yourself in a criminal action?
I have.
Do you understand that you have the right to remain silent? Anything that you say can be used against you in court?
And I choose the fifth. I won't answer
Now
any
this
more.
moment is critical, and honestly, a bit painful to watch if you understand what's happening. The judge is not interrogating him about guilt here. This is something called a Feretta hearing, where the court ensures that a defendant fully understands the risks of representing themselves. But instead of cooperating, he invokes the Fifth Amendment at completely the wrong time. That right protects you from self-incrimination, not from basic procedural questions about your legal rights. And here's the irony. By refusing to engage properly, he's actually increasing the chances that the court questions his ability to represent himself at all. This is where legal knowledge really matters, not just knowing terms like Fifth Amendment, but knowing when and how they apply. Be honest. If you were in this position, would you still go solo in court after hearing all these warnings?
You're required to abide by the Colorado Rules of Evidence and the Colorado Rules of Criminal Procedure. And do you understand the defenses to the offenses by which you're charged? Do you understand that an attorney would be familiar with defenses and requirements to raise such defenses on your behalf? Do you understand that you must proceed by calling witnesses and asking them questions, not arguing or making speeches, but asking appropriate questions, and that you will not be permitted to tell the jury matters that you wish for them to consider as evidence during the examination of other witnesses? Do you understand that it would be much easier for an attorney to contact potential witnesses, gather information, and question witnesses, and to present your case than it would be for you? All right. At this point, I'm going to find that you are aware of the rights that you have and that you're giving up by waiving your right to counsel. You are not choosing to cooperate with the process. But at this point, the court's going to find that you've knowingly, voluntarily, and intelligently waived your right to counsel. We'll go ahead and enter a not guilty plea and get the case set for trial.
I object, Your Honor.
You're the one that asked me to set it for a trial. If you don't want it set for trial, I'm happy to set it for something else. Do you still want it set for a jury trial?
Yes.
Okay. That includes a not guilty plea.
Well, let the record show that I have not entered a plea, that the plea was made for me.
While you're at it, let the record show that the defendant is a dumbass.
You're asking for me to set it for a jury trial. That requires the entry of a not guilty plea. So the court will receive a not guilty plea today. I'll find that speedy trial runs on October 3rd. I'll order that motions be filed on or before May 4th. That'll also be the deadline for endorsement of witnesses and defenses. We'll set a half-hour motions hearing, trial readiness, and jury trial dates. And let's see what dates we have. Motions hearing at 3:30. Okay, June 15th at 3:30 for motions.
Trial will be July 29th.
Okay, July 29th at 8 o'clock for jury trial. Okay, July 14th at 11 o'clock for trial readiness. Trial readiness will be the last day the court will accept any plea agreements in the case. The court will issue a written pretrial order, and we'll print an extra copy for you today so you have those. Be sure to look because there are some additional deadlines and information in there about doing jury instructions and things like that. All right. Thank you very much.
Court had removed the attorney of record and indicated that it would have a new attorney appointed. Mr. Leffers, that has not happened yet. We're still waiting for an attorney to be appointed for you, just so you're aware of that. All right?
Your Honor, is the court going to reset the probable cause conference to next week?
We will, but it looks like Mr. Leffers is digging through some stuff here. What do you have, Mr. Leffers?
Well, I should go through that.
Mr. Leffers, before you start, I gave you a lot of time last week, so I'm not going to give you very much time this week. So if you're planning on giving the court a history lesson in maritime law or self-governance or any of that, I'm not going to have that today, okay?
So I have to stand up for my rights, otherwise my rights are forfeited by my subjection, and I will not do that. Your Honor, are we on the public record?
We are.
Is this a court of common law or admiralty law?
Mr. Leffers, I am not doing this today. I've already told you that. We're not going to go through this.
I move the court to take judicial notice of your oath of office to the Michigan Constitution as ratified without subsequent amendments under the United States Constitution. What say you, sir?
I addressed you last week about my about the oath I took. I confirmed that you had a copy of my oath. I confirmed that.
Thank you. Your Honor, moving forward, Article 3, Section 2, Clause 2 of the United States Constitution says that when a state is a party in a case involving a citizen, that state, the Supreme Court, has original jurisdiction. The state has a conflict of interest. You cannot unbiasedly represent yourself in the state. The state cannot be a victim. Also, we have been made aware that there is some judicial bonds that may have a monetary value, which clearly gives the state an interest in the outcome of the case, which once again is why Article 3, Section 2, Clause 2 of the Constitution exists. The state cannot.
And there it is, the moment where reality fully clashes with misunderstanding. The defendant insists he hasn't entered a plea, but what he's missing is this: procedurally, a trial cannot move forward without one. When he requested a trial, the court is legally required to enter a not guilty plea on his behalf. This isn't the judge overstepping. This is standard legal process. What makes this moment so important is that it highlights a pattern, rejecting the system while still trying to operate within it. You can't demand a jury trial and simultaneously reject the steps required to get there. And from a strategy standpoint, this is where things start slipping. Because instead of focusing on defense, evidence, or preparation, the energy is being spent fighting procedure itself. So here's a question. Do you think challenging the system like this helps a case, or quietly destroys it from the inside?
The state in the territories of the Confederation of the Republic that made up this wonderful place, and all the rights and freedoms that we all have that have been abrogated through policy and procedures.
So are you claiming you're a citizen of the Confederacy from after the American Revolution? And when I say the Confederacy, I mean after the American Revolution and before the U.S. Constitution.
No, sir, this predates even that.
Okay.
I am a living man that follows the Creator's law, the supreme law, the law of the land, which no policy or procedure can abrogate my rights or immunities.
So then how are you relying on the Constitution to say that I don't have jurisdiction if you don't believe that you're subject to that?
Yes.
Supports it.
In the First Amendment, we are one. This is my wife, Jelaine. She's been with me for 24 wonderful years. She has had my back. She has helped me grow and understand and overstand so many wonderful things. The Constitution is set up to protect rights. And I have the right to use everything at my disposal. The Constitution is at my disposal, in addition to the supreme law of the Constitution, as wonderful as it may be. It's not the Constitution. The corruptness that went into it destroyed it. Though it may hold some lingering truth, if you change 10% of 100% of the story, you have deceived everyone that you tell that story to. They will never be able to defend themselves properly. They will never know how to manage themselves properly. If the truth was to be told, then the decision, the rightful will choice would fall on the people. And I am one of the people. Which is why there's also another conflict of interest. The state cannot prosecute me because I am the people. So is my wife, and so are our children.
So it's your belief that the state cannot prosecute criminal laws against its citizens. But if you were a citizen of Texas and violated a Michigan law, would the court then be able, or would the state of Michigan then be able to prosecute that person?
Yes. State of Michigan. The Texas.
No, hold on. It's Mr. Leffers is the one who has.
Well, as I stated,
We are one in our
First Amendment right.
Okay. Mr. Leffers is the one who's before the court. Mr. Leffers releasing any rights that you have. But we're going to reset this then for another probable cause conference next week. And hopefully by then we will have counsel appointed for you. And you can discuss your issues with your appointed attorney.
So I do not accept. Also, I am here on special.
All right, Mr. Leffers.
In the case.
Mr. Leffers, you need to stop. All right. I need you to go out to the front window where you checked in and get a copy of your next court date, because I'm not going to allow you to interrupt the business of the court. And as you can see, you're getting pretty close to that. I'm not saying that you're wrong. I'm not saying that you're right. I'm just saying, again, this is not the forum. That's not what we're here for today. There's a procedure to go through for
what you just watched is a powerful example of how courtroom outcomes are often decided long before a trial even begins. This wasn't about evidence yet. This was about preparation, understanding, and strategy. And unfortunately for the defendant, every warning sign was there. The judge made it very clear: you have rights, you have options, and you have access to legal help. But choosing to reject that guidance while relying on misunderstood legal theories puts you at a serious disadvantage. We also saw how the court balances fairness with efficiency. The judge remained patient, explained the law multiple times, and still ensured the process moved forward correctly. That's the system working as intended, even when one side refuses to fully engage with it. The big takeaway? Representing yourself isn't just risky, it requires deep knowledge of legal procedures, evidence rules, and courtroom strategy. Without that, even strong arguments can fall apart before they're ever heard. Now I want to hear from you. Do you think the defendant truly understood what he was risking here? And would you ever represent yourself in a case like this? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.